Court's going to find that the bond currently established is the proper bond to ensure the public safety of the community. Clearly, there's probably something organic going on with Mr. Tucson, but the threats are so dangerous. And in an area that, let's be honest about it, people walk on. People of the state of Michigan versus Reginald Matthew Tucson, case number 22F5-5110. Good morning.
Good morning, Your Honor. Caitlin Kirby on behalf of the people.
Good morning, Your Honor. Kenneth Overwater, Assistant Public Defender on behalf of Mr. Tucson. I apologize. I was in Judge Frushauer's Zoom room because the matters I had there were going to be quick, but that docket still hasn't started.
Thank you. Okay. Well, my understanding is we have a preliminary examination scheduled this morning, and are the parties ready to proceed?
Judge, I would be helpful if I had a moment to talk to Ms. Kirby, but I believe we will be ready to proceed.
Thank you. Well, I think you're all I've got left right now, so I'll give you that chance. Maybe you guys could do it by cell phone, or I could put you in a...
Cell phone's fine, Judge.
Okay. Thank you. Be sure to mute your screens, is all I'll say.
Yes, sir. Thank you.
You're welcome, especially if you're going to talk about me.
Only in glowing terms, Judge.
Right. Okay, I see counsel is back. We will go back on the record. People of the state of Michigan versus Reginald Matthew Tucson. Case number 22F5-5110. Good morning.
Good morning.
How many witnesses do you intend to call?
Are we running the exam, Mr. Overwater?
I would need about 10 seconds to talk to Mr. Tucson to be sure of that, but I believe so. I'm sorry to delay the court. I did speak with him last night, but...
Could you put them in a breakout room real quickly, please?
Thank you, Your Honor.
If we are running the exam, Your Honor, it is going to be 2 to 3 witnesses. I believe only 2.
Okay, well, it will be important to know for sequestration purposes.
The officers are together at the Ann Arbor Police Department, so they would have to go into separate rooms themselves. And then the other, the victim, Mr. Lang, is on a Zoom by himself.
Yes. Okay, everybody's back now. We'll go back on the record. People versus Tucson, 22F5-5110. Are we ready to proceed?
Your Honor, my client indicated he wishes to waive his right to a preliminary examination this morning and proceed to circuit court to resolve the matter there. I would just note for the record, at an earlier PCC, defense demanded video from the incident at Kroger. That video was tendered to our office, but because of some technical difficulties, I wasn't able to review it last night. We were able to resolve those difficulties this morning. I have had the opportunity to review the video and discuss it with Mr. Tucson, and based on everything that we now know, it's his intent to waive his right to examination and proceed to circuit court.
Ms. Kirby, do the people waive their right to a preliminary examination?
Yes, Your Honor.
Thank you. I don't have your client here to get a written waiver, so Mr. Overwater, if there's no objection, I'd like to address him directly to make sure this is what he wants to do.
No objection. Thank you, Your Honor.
Thank you. Good morning, Mr. Tucson. Do you understand that you have the right to a hearing that's called a preliminary examination?
Yes, sir.
And if you held that hearing, the prosecuting attorney would be required to show that there's probable cause to believe that you're the person who committed the crime that you've been charged with?
Yes, I understand.
And in fact, I see they have 3 witnesses here this morning. It appears 2 police officers from the Ann Arbor Police Department, as well as what I assume to be a civilian witness. And they were here and ready to testify, but you would like to waive your right and go straight to circuit court. Is that correct?
Yes, that's correct, Your Honor.
Court will find that the waiver in this matter was knowing, understanding, and intelligent. Furthermore, the court will find that the prosecuting attorney, having waived her right to preliminary examination, the examination is waived. Mr. Overwater, do you acknowledge receipt of the information in this matter?
I do, Your Honor. I'd waive formal reading. My client would stand mute.
Court will enter a plea of not guilty on your client's behalf. This matter is going to be assigned to Judge Darlene O'Brien. So we will schedule a video conference arraignment November the 17th, 2022 at 1:30. Bond in this matter was previously established at $10,000 cash or surety. Does either side wish to address bond?
Yes, Your Honor.
You may.
Your Honor, the facts of the case make it very, very clear that my client was in the midst of a psychological or psychiatric episode at the time of the offense. There are things that he said to the officers that were highly delusional. And while these are violent offenses, the factual allegations of the resisting are relatively mild. It's an arm grab, standing and kind of looming a bit and sitting back down while at the hospital. Obviously, those allegations, if proven true, are sufficient to establish the facts of those charges, but they're, relatively speaking, milder in nature. As far as the felonious assault is concerned, the complaining witness in the case would have testified that he did not actually see the weapon, just believed him to have one in the based on the things that he had said, which were violent allegedly in nature. But another witness who was present at the Kroger reported to police that while my client was holding a pocket knife, that pocket knife was closed. So the blade was not extended. And while that also may reach the level of satisfying the elements of the offense, it is as well a very muted and mitigated set of facts to establish those offenses. My client is currently receiving medication. He has provided me with his contact information. He has a 1-year lease on an apartment on Greenbrier in Ann Arbor. He has family in the area and strong community ties. He has a 7-year-old son. He collects SSI for physical and mental disabilities. It's his hope that he will be able to raise bond to be released so that he can keep his apartment and keep his place to live, because the eventual resolution of this case is going to involve Mr. Tucson engaging with community mental health and maintaining his mental health treatment. That's the cause of these incidents, and that's the only thing that's going to prevent them from happening. And if he is rendered homeless, that will be counterproductive. So I would ask the court to consider, at the very least, reducing his bond to $10,000, 10%. He does have another bond on a misdemeanor matter that's set at $10,000, 10%. So he would need to raise $2,000, but he believes between his SSI and the help of family, he can do that. That would be sufficient to secure his appearance in court, and he would be willing to comply with whatever conditions the court set, particularly that he comply with any recommendations or treatment through CMH.
Thank you. And could you, Ms. Kirby, could you tell me anything you know about the defendant's past criminal history and what his status was on the date of this offense?
Yes, Your Honor. So I would just say, while he did make the threats, and yes, the pocket knife was not open, the threats contained that he was going to commit genocide after he gets out of jail. He told the officers that he was going to find their family and murder them in front of them. He said he would kill Ann Arbor police officers when he was released from jail, and he would return to Kroger and mess with the gas line so the place would blow up. He also made many threats stating that he would rape and commit sexual acts on the officers as well as their family and their children. And then while at the hospital receiving the treatment, he was seated into a chair. He said he was going to break the chair arm off and then stab it into one of the officers' neck. The FA threat to the Kroger employee, he said, "You're lucky I do not stab you right now. I should stab you in the back. I will stab you right into your neck." And the threats continued all the way until he was lodged at the jail, saying things that continued on to the threats, and then using both hands to attempt to hit at the officers while he was in their custody. As far as his criminal history, he has some theft, prior retail fraud. He also has some controlled substances charges, some of those dating back into the 1994-95 range, and then the controlled substances cases being as 2007.
Court's going to find that the bond currently established is the proper bond to ensure the public safety of the community. Clearly, there's probably something organic going on with Mr. Tucson, but the threats are so dangerous, and in an area that be honest about it, people walk on eggshells anyway. I shop at that Kroger, and I know when you pull in after dark and you see all the signs about the video cameras and about how the whole place has to be videoed now for anybody who wants to go shopping there. It's an area for soft targets. And so for him to say he'll be going back there is very troubling to me. To have issued the threats to the officers is very troubling to me. It's not part of their job, as is assumed by, I'm not saying anybody here makes that assumption, but some people assume the cops, that just goes with the job. That's part of their hourly rate. It is not to have any hands placed on them or to have these types of threats made against them or their families. So I find all of that deeply concerning. We'll keep the bond at $10,000 cash assured. And he did get an in custody date, which is November 17th, 2022 at 1:30 before Judge O'Brien. So thank you all very much.
Thank you, Your Honor. Mr. Tucson, give me a call from the jail, okay?
Am I able to say something? Because I was released and none of that
happened. Don't say anything right now.
That happened when I was released.
Mr. Tucson, it's not going to help. Give me a call from the jail, okay?
Yes, sir.
Thank you all very much. Have a good day.
Thank you, Judge. Have a wonderful day.
Thank you. When I was released, so I'm back in custody in over a month. None of that happened. Wow. They can kill black people.
What started as a routine day in court quickly turned into a powerful reminder that attitude can influence the outcome just as much as the facts of a case. One defendant's constant interruptions, profanity, and refusal to follow the judge's instructions only made his legal situation worse, while another case showed how the court carefully weighed mental health, public safety, and accountability before making its decision. No matter what side of the courtroom you're on, respect, self-control, and taking responsibility can make all the difference. These real courtroom moments prove that every word, every decision, and every reaction carries consequences. Now it's your turn. Do you think the judges handle these cases fairly, or would you have made a different decision? Let us know in the comments below. If you enjoy watching real courtroom drama, shocking legal moments, and in-depth case breakdowns, don't forget to like this video, subscribe to the channel, and turn on notifications so you never miss our next viral courtroom case.